I beg to pardon, Lordship.
Yes, Mr. Mishra.
It's not one criminal appeal I filed yesterday. In a peculiar manner, the agreed person has not filed the FIR, and the fine is 1,000 in a vigilance case, and sentence is 4 years.
Please give it.
Maybe call on tomorrow, man.
Yes.
Because unnecessary to keep him
Please,
behind the
please see that there is no defect.
I have no defect, but it is only I'm giving the diary number.
Okay.
But there's no defect. But if your lordship will direct to come in tomorrow, they will immediately.
No. Diary number means there may be some kind of defect.
No. They, on receiving, they should do it, but the process your lordship knows that.
No, it will come.
But if your lordship will direct tomorrow, they will immediately do the staff reporting.
Okay.
And there is no defect.
Yes.
Lordship, on bail appeal application 8611/2023, the petitioner prays for the interim release on the ground of his illness of his wife. Immediate surgery to
Tied up in matter, petitioner in custody near about 4 years.
Discuss for chain of nomenclature from serial to barrel. Tomorrow.
Third as to admission, appeal 3 years conviction. The statutory period would expire on 26th and holiday can take out 2 months.
All
Type of matter, I'll let 3 years in jail cost. Bell.
I want to ELPL 10,271/23. I want to mention ELPL 10,271/23.
Okay, note it down, Mr. Patay. All right.
May I please?
It will come tomorrow or day after tomorrow.
May I please, Your Lordship?
Yes.
Your Lordship, there is a criminal revision number 439 of 2022. 439 of 2022, Your Lordship, CBI matter.
Yes.
Lordships have directed this matter to be listed specifically. The problem, Your Lordship, is that we had challenged 13(1)(d) discharge order in revision. But he has got an order from another court that the trial will be expedited and it will be finished. So if this matter is not listed, Your Lordships, that will become infructuous.
Okay, it will be listed tomorrow.
Obliged, Your Lordship. 439 of 2022.
Yes, noted down.
Obliged.
Supplemental list item number 1.
My lord, this is an application against the judgment of conviction and sentence.
What is the sentence?
Conviction and sentence.
What is the sentence imposed by the trial court?
5 years
Sir?
and 10,000 fine.
Yes, 5 years and 10,000 fine.
You are on.
Item 2.
Yes,
May
Mr. Dan.
appellant convicted under section 13(1)(d) of the Prevention of Corruption and sentence and
What
under
is the
section
sentence?
420, 468, 471,
Sentence,
120
sentence.
IPC. Sentence to undergo the operating part of lordship.
Maximum sentence is
Maximum 2 years.
2 years.
Lordship.
It is run concurrently.
Yes, lordship.
Okay, yes, Mr. Das.
No copy has been served till date.
You have not served any copy?
Yes, copy.
No copy has been served till today.
CBI matter.
Oh, CBI matter.
Lordship.
Mr. Naik,
Mr. Naik.
Yes, Your Lordships.
the CBI matter, you have received the copy?
Yes, Your Lordships, I have received the copy.
3-year sentence he was on bail.
Yes, Your Lordships.
Admits Mr. Sarthak Naik, learns special public prosecutor first. He was on bail granted, stay realization of fine. Yes.
Obliged.
Item 3.
My lord, the operating portion of the judgment is 49, 3 years RI and 5,000 fine under section 13(2) of the PC Act. Humble prayer is to admit this appeal.
Maximum sentence is 3 years.
3 years.
You were on bail during trial.
I was, and also I am.
Yes, Mr. Das.
Yes, my lord, I have received my copy. I will file my appearance move by the end of June, my lord.
Admit he was on bail. After conviction, also bail allowed. So bail granted. Stay realization of fine. Yes.
Free copy of your order.
It is Patnaik, Learning Council. You are appearing from which virtual high court?
For appellant Rajendra Das.
Stand on the that say system assistant code. This is blocking. Okay, now it's visible. Yes. System assistant କହିଦବ ସେ ପଛପଟେ ରହିଯାଉଛି ଦେଖାଯାଉନି. It should be prominent. Okay. Yes. Next.
My lord, free copy of the order will be.
Free copy of the order. Mr. Das names to be reflected. Yes.
Item 4.
May please, your lordship.
Yes, Mr. Sahu.
Yes, lordship. Maximum sentence is 2 years, your lordship. For offence under section 13(2), read with 13(1)(c) of the PC Act and under section 409 of the IPC. In both the.
You were on bail during trial.
Yes, your lordship.
Yes, Mr. Das.
Yes, my lord, I have received the same order, my lord.
All right.
I will file my appearance move by the end of June.
On bail granted, stay realization of fine. Yes, free copy.
May I pray one thing, my lord, before my lord?
Yes.
Item 55, I have got 2 other matters in different courts. My lord, item 55, leave to continue. My presence may kindly be noted. Item 55.
What is to continue?
Leave to continue. The appellant has died. Wife has filed this IA and delay is there.
You have no objection that you want.
No, my lord, as your lordship passes the order, my presence may kindly be noted.
What is the number 55 and?
Item number 55, CRL 912/2023.
Yes. What is the other one?
Registry may be directed to reflect my name on the cause list.
What is the other one, Mr. Das?
Only 55. Only 55.
Right. Call the list. Yes.
I have got 2 other matters in 2 different.
All right. Yes. Next.
Obliged, my lord.
Item 5.
Lordship, I am in risk, your lordship. I plead. I'm obliged.
Item 6.
Lordship, Lordship seeking bail, Lordship.
Press matter. Same order as
Copy
in.
not so.
Copy the
Copy. Another prayer, Lordship. Another 2 bail two CRL penny are arising out of same FIR, Lordship.
ତାବେଲେ କଣ ଆଧିରେ କପି ଦେବେନି ନା
କପି
ସେଇଆ ତ ସେ କହୁଛନ୍ତି କପିଟା ଦେବେ ଆଉ କଣ ଏତେ
ଅନ୍ୟ ଦିଟା ମ୍ୟାଟର ମଧ୍ୟ ଆସୁ
2 copies want to be submitted. One is to be written, the other is to send. What is the connected numbers?
CRLA 134 of 2024.
This matter along with CRLA number
134 of 2024.
Yes.
And CRLA 131 of 2024.
See the availability of the case diary may be there, Mr. Tripathi.
Yes,
okay. Next.
Item 7.
Yes, Mr. Paul.
Meet.
Mr. Patnaik, yes.
Meet if your lordship. Here in this present case, the case is arising out of a complaint which are forwarded under section 156(3) and PS case was registered.
Earlier anticipatory bail application was rejected.
No, my lord. In respect of 2 other co-accused persons, my lordship was
that number is for 2 other accused persons.
Yes. I have annexed, my lord.
Okay.
Running page 19.
So those anticipatory bail applications have been allowed.
Allowed, my lord. And so far the present petition is concerned, he has played no role. Accused number 1, he has registered. Sorry, accused number.
Mr. Tripathi.
Yes, my lord.
or the learned counsel for the petitioner, learned counsel for the state, considering the submission made by the learned counsel for the petitioner that the case arises out of a civil dispute between the parties, offences are tried by magistrate. Similarly situated co-accused Antarjami Bodu has been directed to be released on anticipatory bail in ABL APL number 1513 of 2022 as per order dated 5/5/2022. And after hearing the land counsel for the state, I am inclined to release the petitioner on anticipatory bail allowed. Yes.
Obliged.
Item 8.
Yes, Mr. Montia.
Kind of matter, present petition is custody from 8/4/22, my lord.
Is it the first application?
Yes.
Second.
Okay, you have received the case diary.
No. The
I
first
have
time
been
it has
Praise matter.
yes.
All right, get the case diary and
I have annexed the deposition. You will also have liberty given to.
no, it's all, but he has to obtain the case diary and verify. Any co-accused has been released on.
No,
bail.
only one.
Okay. So it will come after 1 week.
Yes.
Yeah.
Item 9.
302 press matter.
Okay.
No.
What is this number, Mr.
This is that is
Mishra?
the 17/9/2019.
Ah.
The petitioner was before the Supreme Court in BLAPL 5153.
It was earlier approved this.
It is withdrawn to file a better application. The land counsel for the petitioner files a memo to
what is
withdraw
the-
the bail
what is the
application in order to
present
file a
position?
better application.
What is the present position in the
Yes,
trial?
that
court?
is the petitioner is extremely poor person. He could not engage. That is why after, even though your lordship granted in 2019, he could not come earlier than the present occasion.
No, I just want
Yes.
to know that whether the trial has come.
Yes, that is what I'm saying. They have given annexed the copy of the bail. Your lordship can see the order. Rejection order. He relied upon the PW 2, 3, and 5. I have annexed the evidence of PW 2 and 3, 5. They don't implicate him.
No, Mr. Mishra,
Yes. Out of
PW, you have just annexed 3 copies of the.
yes, to
Okay.
which the large session relied on to reject the petition.
Okay.
There are, I have stated, the
But
your lordship can
this
see,
PW 5, Mr. Mishra, it reveals that he was examined on 30th January 2023.
yes,
But thereafter,
yes.
1 year and 2 months have
Yes.
almost
I
passed.
have stated,
So what
out
is
of-
the present position?
yes, out of my lord 37 witnesses,
Yeah.
only 11 are examined.
Okay.
Something like that.
All right.
Yeah.
You
Yeah.
are not having that case diary and.
Yes.
All
It is a 5 years the appellant is custody.
All right. The learned counsel for the state 6 some time.
I have got all the evidence. The last witness examined on the PW 11 on 10th October 2023.
At 10th October.
PW 11.
So why don't you supply the copies of other witnesses? All right.
I will
And
supply.
also
But
file a
since he has
copy. No, it's all right. He has relied upon, but let's not.
should I give it the certificate copy to your lordship? You can say.
To the court and also to the state council a copy. The learned counsel for the
I'm
state
giving
submit
it,
that he has not received the copy of the case diary. So also the instruction about the criminal antecedent, 6 some time to obtain the same. Mr. Mishra submits that he has instruction that out of 37 charge sheet witnesses, kitne witness?
11.
11 witnesses have been examined, and some deposition copies he has annexed to the bail application, and he submits that the rest of the deposition copies will be supplied to the learned counsel for the state during course of this week, as well as a set of deposition for those witnesses to be filed for the court during this course of this week, court of this matter, such and such day. Yes. And CDCF to be obtained in the meantime. Yes.
Item 10.
Wait, please, Your Lordship.
Is it a fresh matter?
Your Lordship, this is a tied up matter, Your Lordship.
No,
Or-
tied up man aji pratham
I-
thara ପାଇଁ
I
ଆସିଛି ତ
will.
case diary ନଥିବ ବୋଧେ.
Your Lordship, OPID has been.
Where is Mr. Have you given a copy?
Yes,
to
Your Lordship. While filing, a copy had been served on them.
OPID ଲେଖା ହେଇଛି present room.
Lordship, we have.
Right. Is this matter day after tomorrow, indicating the names of Mr. Vivekanand Bhuya and Mr. J.P. Patra in the cause list. Let it come day after tomorrow.
Your Lordship.
Item 11.
Yes, Mr. Das and Mr. Behera. You have received the case diary?
No, my lord, first time it has come.
First time it has come. So get the case diary and criminal antecedent, non-appears for the petitioner, CD and CA to be obtained. Okay, yes, next.
Item 12.
Yes, Mr. Das, trace matter.
My lord,
Yes.
no, trace matter, but earlier by virtue of your lordship's earlier direction, he was released on bail interim for 3 months. Thereafter he submitted. Now, for the second time, I have approached your lordship because he is in custody since my lord 2022. In the meantime, out of 24 charge sheeted, 27 charge sheeted witnesses, 15 witnesses have already been examined. So for your lordships,
No, have you given those
just
copies?
now I'm serving
Serve the
this
copies
is
to let
certified copy I am serving for.
All right. The learned counsel for the petitioner filed the certified copy of deposition of the witnesses already examined in the
15 witnesses.
15 witnesses already examined in the trial court, and also
Serving
supplied the same to the state counsel in today, who seeks some time to go through the same and obtain the case diary and criminal antecedent, if any, against the petitioner. Put up this matter. Put a subtap.
Thank you. Obliged.
Item 13.
May placement. First
Trace-
came
trace matter.
case matter. Your lordship granted bail to the other co-accused persons. In the meantime, the original case, 8 witnesses have been examined.
All right.
That I am supplying, madam, and also supplying the
Supplied the filed the deposition copies of the witnesses.
8.
8 witnesses taken on record. Copy also supplied to the state counsel, who seeks some time to obtain the case diary and instruction about the CA. Hello? Yes.
Item 14.
My lord, I may be pardoned, my lords. Actually,
Fresh matter.
I was no, it's a fresh matter, but actually I was not aware of the fact that a previous bail was rejected by this honorable court.
You want to incorporate it?
No, if in the
Or
certificate
file a
I have not given it. That has been rejected. My lord,
Please file a memo
My-
indicating that
my lord.
that inadvertently it has been left out. Just take the one paper and file
My-
that.
my-
Everyone come to paper them. Learned counsel for the petitioner has filed a memo indicating that previously, how many occasions this petition?
One.
Previously, the petitioner approached this court in BLAPL number such and such, which was disposed upon. You are aware about the disposal date.
No, my lord, disposal date I am not aware. I saw it in this.
Why are you not
that,
using
yesterday.
your mobile phone?
Yesterday,
to trace it out?
yesterday, my
Find
lord.
it out. Yes, next.
One of the offenses
Is
is FD.
So,
376
one of the offences is extra copy to be served,
My-
CDCA to be obtained along with the confirmation letter regarding service of notice and so on. Yes.
Item 15.
Yes,
Please, your lordship. My lord, I am in virtual mode, my lord. My lord, petitioner is a lady, my lord. Only inside custody, my lord.
Case matter.
Yes, please.
Man,
So get the your door window screen looks very attractive. All right. So so it is CD, CA. There is nothing to be noticed for the informant, Mr.
No.
man.
All right. It will come after 1 week. Yes, next.
Obliged, man.
Item 16.
This is a fresh matter. 3 CST Act is there. So notice.
Notice extra copy to be served. Those CD you have obtained or not?
No, first time.
Okay, the CD and CO. Yes, next.
Item 17.
17 में लगा 500.
Not Passover, it's a phrase matter.
Yes, madam.
So any offense for which notice is required?
No. 302 offense.
All right. CD, CA, and 1 week after. Yes, next.
My lord, kindly be directed to status report. My lord, can I call for the present
Status report you want? All right.
My lord.
Call for the status report from the learned trial. Yes.
Item 18.
My lord, the petitioner in custody 211
Phrase matter.
Yes, but in bail last time your lordship has granted 2 months bail for one witness is examined.
You want status report?
Yes,
All
yes,
right.
my
CDCA status report. Yes, next.
Item 19,
Extended.
item 20,
Extended.
item 21,
Okay. I beg pardon, my lord. Today I have missed the list.
You want on which day?
Any date, my lord.
ଆପଣ କୁହନ୍ତୁ ଆପଣ କୋଉଟା convenient ହବ?
Ara week ରେ ଯେକୌଣସି
Next week. Next week it is not possible because only 2 days are there. It will come on 2nd April. All right.
In the meantime, the defect I will remove.
Okay. 2nd April defects to be removed in the meantime.
God bless.
item 22,
May I plead the Lord?
Yeah.
On the last occasion, my Lord, the Lordship was pleased to, my Lord, call for the custodial certificate of the petitioners. My
How
Lord.
many appellants are there?
4,
My
my
Lord.
lord.
In this criminal appeal?
My Lord, I am appearing in two. My Lord.
No, there are 4 appellants.
There are 4 appellants.
So you are appealing Next case.
Item 24.
My lord, address verification sought for, my lord. Previous date, my lord has pleased to direct the common advocate to address verification. Address verification of two appellants.
Right. So phrase address of
Given, my lord.
you are supposed to give. You have already given.
Given.
Yes, Mr. Tripathi.
Yes, my lord. He has given the name and address,
Yeah.
but the PS district nothing has given. How could I put the Bihar con district? Kond? At Parsa.
Mr. They are supposed to obtain instruction through the police station. So आपण लिखी देबे बिहार. बिहार टा कोन एडिट ये जागा ना केमती क्या? कोन ना?
Parsa.
मु जान सेटा कोन सेटा पुलिस स्टेशन ना ना कोन? Why are you not furnishing what a location to jibe semane? They are supposed to get it through the PS. So please furnish the PS number and the name of the village or the town, whatever it may be. Give the proper address so that it can be ascertained. Earlier you had given, it was found to be not correct. Now you are supposed to submit the phrase address. Phrase address should be in proper form. I am directing you phrase supplied. The Learning Council for the state pointed out that the address which is furnished by the Learning Council for the appellant is insufficient to ascertain the correctness and therefore the appellant counsel may be asked to furnish the press correct address. Mr. Mahapatra and counsel submit that he will furnish it by next week. Put of this matter and such answers there. Yes, next.
All right.
Item
Beg your
24.
pardon, my lord. Can it be 23? Can it
Tomorrow.
be? Okay.
Item 25.
Item 25. I am appealing for the first item, my lordship.
Yes.
Here the petitioner is in custody since 2000.
Earlier bail application rejected.
No, my lord.
Pardon me, Lord.
Yes.
May it please the Lordship. Lordship, I have received prisoner petition for sub-item 2 and 3, Lordship. Lordship, I may be permitted to file the Vaklatnama, Lordship, to
Please.
that extent.
Please wait. I am taking up number 1.
Yes,
So,
Lordship.
you have it was not earlier rejected.
No, my lord.
All right. You have got the deposition copy, Mr.
No, my lord. It has not supplied.
What is the offense here?
Offense is, my lord, under section NDPS Act 2B, 2C and 27.
20B or 20B?
20B.
20B, 2C. Okay. So what is the sentence imposed?
10 years, Lordship.
How many years you are in custody?
Near about 5 years, my lord, since 2019.
2019. So you obtained that custody certificate.
Yes.
So custody certificate to be obtained and list this matter on such and such date. So yes, Mr. Mahanti, you are filing the VNAMA.
So during course of the day, I will file the Vaklatnama.
Mahanti Learning Council appearing for the appellant.
Appellant number 2 and 3.
VNAMA during course of the day.
Yes, Lordship. In item number, CRLA number 514, in
Right.
item number 2 and 3, Lordship.
Right. Item number
514.
514.
14 CRLA number 514, Lordship. Beg your pardon.
You will file VNAMA for whom?
Appellant number 2 and 3, Lordship.
You will file VNAMA for appellant number 2 and 3. Okay. So put up this matter along with your Uparata CRLA number 513. And you also obtain the custody certificate
Yes,
of
ma'am.
this matter, this 2 and 3. Or you file for all the appellants.
Yes,
ma'am. Yes.
Item 26.
Yes.
Item 26, my lord. In the vigilance case, my lord, the 2 years conviction. He is not getting single pie. His wife is suffering from, my lord, the over in Kersinama. I read people fix about that.
There are hundreds of cases where
convicts are not getting a single fine. I have already
vigilance cases are they are of
courts of argument are prepared. At least 15 minutes will
no, ଆପଣ କହିବେ 15 ମିନିଟରେ ସାରିଦେବି ଆପଣ ସେଇ ଟାଇପ ର
any that matter conviction କରନ୍ତୁ ଗୋଟେ sir ଲୋକଟା ମରିଯିବ ପୁଣି
ନା ମରିଯିବ ସେ କିଏ କହୁଛି ମୋ ପେନସନ ବନ୍ଦ ହେଇଯାଇଛି କି ଅମକ ହେଇଯାଇଛି
only 2 years conviction
old appeals are pending how can I give preference
only 2 years conviction lordship that is the
ଓ ଆପଣଙ୍କର ଅପିଲ ଟା ହଉଛି 2021 ର ଭିଜିଲାନ୍ସ ଅପିଲ ପୁରୁଣା ଅପିଲ ଗୁଡାକ ପେଣ୍ଡିଂ ଅଛି ଯୋଉଥିରେ ମଧ୍ୟ ସିମିଲାର କିଏ ରିଟାୟାର୍ଡ କରିଗଲାଣି ଓବିୟସଲି ଡିସମିସ୍ ହେଇଥିବ କନଭିକ୍ସନ ପାଇଁ
dismiss sir misappropriate amount of money 19 lakhs lordships
will consider your application after summer vacation this interim application for fixing date of hearing should be considered where is Mr. Das Sriman Das vigilance nobody is present in vigilance ये श्रीमन दास खबर देले नले का अन्य की काउंसिल श्रीमन दास को कौन matter to be considered you keep it in May 2024 for consideration of the interim application yes next but you are fine
written note
you will देव obligate one written note है date fix of
Item 27.
please lordship
I have not mentioned it, but ask him to remain present.
Yes, my lord. Maybe passed over. Maybe passed over. I am intimating him to.
It is adjourned to May 2024. Okay, for consideration of the interim application for fixing early date of hearing. So
yes, my lord. I am intimating. I am intimating immediately.
Somebody should remain present when the matter is placed. Maybe through virtual mode. We are not insisting your personal presence here. All right. Yes. Next.
Maybe passed over, my lord. I am intimating.
No, just intimate that the case is adjourned to May 2024. I have not mentioned that he is not present. Okay. All
yes,
right.
my lord.
Yes.
Yes, my lord. Oblige, my lord.
Item 28.
Your Lordship, I am appearing on behalf of Vibhuti Bhushan Nanda. As he discharged yesterday, as he have a cardiac problem, I have told before, you have given
You want adjournment. To which date you want?
2 weeks.
2 weeks. What is your name?
Jewel Das.
Keep the name in a slip. So also appearing for Vibhuti Bhushan Nanda. 6 for an adjournment for 2 weeks put up this matter in the week commencing from 8th April to do. Okay, 8th April 2024. Both the matters. All right. Next.
Item 29.
Yes, Mr. Das, MB Das.
I'm pleased. Not this is a appeal against acute.
What is this interim application you have filed for dispensing with the impugned judgment? It's a case of conviction.
No. In the initial stage in the trial court, it was the accused was convicted, but subsequently the appellate court, that is before the sessions judge, he was acquitted. And challenging that acquittal order, I filed.
So if you are challenging the acquittal order,
Miller.
you should file the certified copy of the impugned judgment. So why are you filing the application for dispensing with this? You have to file both the copy, the conviction, so also the acquittal order certified copy. So why it is to be dispensed with?
All those things has been filed in the earlier petition, Millard, which has been numbered as criminal appeal number 765 of 2019.
I don't know. What is that criminal appeal?
Initially, that has been filed as 765 of 2019. Subsequently, it was turned up as leave to appeal.
Okay, you mean to say that in the
leave to appeal, all the documents.
All the certified copies
Yes,
are available. I checked the records of CRLLP. In the CRLLP, 15/2021, whether the judgment.
No, criminal appeal, Miller. Criminal appeal number 765 of 2019. It has been filed.
You said that criminal appeal converted to CRLLP?
Yes.
So now the new number is to be seen because CRLLP 15/2021 has been disposed of. Achi, certified copy. CRLLP number 15/2021, right? And that judgment is 21/2019. पढ़ी पारन कि लिस्ट देखो से फाइलिंग करछन डिस्पेंसिंग विथ द सर्टिफाइड सी द लिस्ट कॉज लिस्ट फाइलिंग सर्टिफाइड कॉपी ऑफ इम्पुग्न जजमेंट डेटेड 21/2019 passed and the judgment passed by so and so, whether both the judgments are available in that CRLLP file or not. Both the judgments, trial court and appellate court. So you do one thing, since the certified copy is available, you file the Xerox copy of those documents, take back the certified copy from that CRLLP record. I will ask the registry to give back so that you can file it here in this CRL, right? IA number so and so, this is an application for dispensing with filing of the certified copy of the impugned judgment dated so and so. Mr. Das, Land Council appearing for the appellant submits that both the judgments are available in the records of CRLLP number 15 of 2021, and he may be permitted to substitute the Xerox copy in the CRLLP 15 of 2021 and take back the certified copy to file in this CRLL. Permission is granted. Matter to be listed immediately after memo is filed with the certified copy of the impugned judgments by the Land Council for the appellant. Clear? All right, next.
Notice also required.
So let the matter be first regularized, then we'll see.
Item 30.
What are the defects, Mr. Chand? 4A and 4A is 12 टंका 65 पैसा not paid on the certified copy annexure 2, and 9 is this margin not proper means what margin? Oh, I see. ଆପଣ ପୁରା ନେଇଯାଇଛନ୍ତି ସେ ଶେଷ ପର୍ଯ୍ୟନ୍ତ ଗୋଟେ ଅଛି ମାର୍ଜିନ ଛାଡିବେ ଏତିକି ଏତିକି
ignore it. And so far 12 rupees, I'll it in course of the day. Nowadays,
So they are right. There is pointed out that how much margin is to be from the right, left, and so on. So ଆପଣ ପୁରା ନେଇଯାଇଛନ୍ତି ଶେଷ ପର୍ଯ୍ୟନ୍ତ page ର. So the reason is that they may face difficulty while preparing the paper book. Paper book ର ଗୋଟେ A4 size ଥାଏ ତ.
A4 size A4 size.
All right, defect number 9 as pointed out by the stamp reporter is ignored. Land counsel for the appellant undertakes to remove defect number 4
in course of the day.
In course of the day. In course of the day, matter be listed immediately after the defect is removed. Yes.
Item 31.
Yes.
Please, Your Lordship.
Item 35.
My lord, on the last occasion, that is on 4/3/2024, my lord, the lordship has directed the State Council to obtain the custody certificate.
Yes, Mr.
I have received the custody certificate. I have received the custody certificate, man, not in proper manner.
Not in
proper manner. Certificate हिसाब से निकाल लिखी रही थी. He is in remain in jail from 3/2/2019 to till date.
3/2/2019
to till date.
till date माने तार date of certificate थिबो तो
हाँ देइछि but not in
हिसाब कले केते होउची
5 years to
1.
3/3/2 हाँ 5 years 1 month ये जो तार फॉर्मेट आउची ABC जो क्लॉज करी दिया सेटा देइनी. So what is the sentence imposed?
10 years.
For the offense?
Offense 376(2)(f)(n). My lord, your lordship last time rejected on it on
what
14/2/2023 and directed that renew
the sentence.
half of the sentence.
So now, as per this, he has undergone the half of the substance. All right. The Learning Council for the state has produced the custody certificate from the sworn Sohala, which revealed that the petitioner has already undergone half of the substantive sentence imposed by the Learning Trial Court. Learning Council for the petition submits that earlier, when the petitioner approached this court for bail in IA number 823 of 2022, as per order dated 14/2/2023, the bail application was rejected and liberty was granted to the petitioner to renew the prayer for bail after serving half of the substantive sentence. After hearing the Land Council for the respective parties, since the petitioner has already undergone half of the substantive sentence, and there is no chance of early hearing the appeal, I am inclined to release the petitioner on interim bail for a period of 3 months. Matter to be listed on such and such date, he has to file the surrender certificate. All right. IA disposed of. Yes.
Item 36.
Yes, Mr. Mishra.
My lord.
obtain the certified copy and file the same, giving copy thereof to the land council for the state. 3 saptah per date fix up for the. Yes.
Item 39.
Yes, Mr. Das.
My lord, on behalf of Mr. Das, we pray for adjournment. Let it come in after vacation.
After
Vacation.
means
We will file the deposition copy in meantime.
deposition copy. You have already supplied.
No, not sir. Very nice.
So,
They do.
okay. What is your good name?
Sujata Vardhan.
Take down in the paper. To also submits on behalf of Mr. Suryakanta seeking for an adjournment till after summer vacation, and will supply the copy to the Land Council for the state. Put up this matter after summer vacation. Yes.
Item 40.
Please, Your Lordship.
What is this criminal
Lordship,
appeal?
Lordship, it is against the acquittal judgment under section 307. The last occasion, Lordship observed that the appeal would actually lie to the sessions court, district court, my lord, and therefore Lordship wanted that I should verify it. Lordship, because the trial was held under section 307, we thought that the proper forum would be the High Court. And as your Lordship was correct, now Lordship may kindly grant liberty so that we can go.
You take the certified copy of the impugned judgment and go to the appropriate court.
Yes, yes, Lordship, certified
Land Council for the appellant seeks permission to withdraw the criminal appeal with liberty to approach the Court of Sessions in filing an appeal under section 372 of CRPC. The certified copy of the impugned judgment be returned to the Land Council for the appellant on being substituted with a Xerox copy. All right.
Then the condonation of delay of
if any, if it is, I am giving you 2 weeks time. If the appeal is filed within a period of 2 weeks with an application for condonation of delay, the London Appellate Court shall take into account section 14 of the Limitation Act while considering the delay condonation application. All right.
Highly obliged, Lordship.
Item 41. Item 42.
Yes, Mr. Pradhan.
Yes, ma'am. Well, here the appellant has been convicted under section 304 part 1.
Whether it was earlier rejected?
No, first time.
Have you supplied deposition copy?
I was supplied.
So what is the conviction and what is the sentence?
Conviction for
10
10 years, Miller.
304 part 1.
Part 1.
You are on bail during trial?
No.
So since when you are in custody?
Since custody 11/12 2018, Miller.
Oh, how many years it is?
More than 5 years.
5 years and 2 months. Okay, 5 years, 3 months it will be. 5 years, 3 months. Eyewitness is there?
Yes, my lord.
What is the name of the deceased?
This is Monisha Munda.
Monisha?
Monisha Munda.
Lady.
Lady, Miller.
Who is the eyewitness?
Eyewitness PW 27 and 28.
PW 27 and PW 28.
28.
So what is the weapon of offense used to
Stone, Miller.
Huh?
Stone.
How many blows you have given?
My lord.
How many blows with the stone you have given? Single blow or more than one?
There is no such, sir.
On what part of the body you have assaulted?
Over the head.
Head. What is the cause of death?
Cause of death, my lord.
With the doctor?
Initially, PW9 was the doctor, my lord. But subsequently, PW 32 doctor who has made the
PM.
The cause of death is a day chance.
Cause of death is as per?
So they named 32 statement.
Yesterday I have received Miller.
That is there in the judgment in para 8 years.
Okay, 32 indicates cause of death is due to craniocerebral injuries resulting from hard and blunt and heavy impacting. So it is getting some kind of corroboration from the medical evidence, and he has also
leading to discovery is also there.
Are the land and counsel for the petitioner and counsel for the state. The land counsel for the petitioner submits that the petitioner was taken into judicial custody on 11/12/2018, and he faced the trial as UTP. And as such, he has already undergone 5 years and 3 months of sentence out of 10 years of sentence imposed by the trial court. Further submits that no chance of early hearing and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Land counsel for the state opposed the prayer for bail. Place the statements of 2 eyewitnesses, PW 27 and PW 28. So also the doctors, PW 9 and PW 32. Further submits that apart from the eyewitness statement, there is evidence relating to leading to discovery of
Stone,
the weapon of offense.
PW 10 and 11.
Instance of the appellant which is deposed to by PW 10 and PW 11. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced, sentence imposed by the trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail subject to condition, shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail, stay realization of fine. Yes, oblige.
Item 43.
Yes, Mr. Nayak.
Milord,
Item 44.
Yes, Mr. Das.
May I please, Your Lordship? The old man, he has been convicted under section, my lord, 20B, 21C of NDPS Act, my lord, to undergo trial for 10 years and to pay fine of rupees
What is
1.
the sentence you have undergone?
Till today, my lord, as per the custodial certificate, my lord, another 2 months is required to complete the 5 years.
Okay, put up this matter after summer vacation. Yes.
Item 45.
Yes, Mr. Rautray.
May I please?
Item 46.
Yes, 44.
46.
Engagement of Tapanjyoti Pani.
On behalf of Tapanjyoti Pani, I have entered my appearance for the appellant number 2, Lordship, on the strength of prisoner petition.
I'm appealing for the appellant number 1, Your Lordship.
No, this prisoner's petition at flag X is for LTI of one Sangi. So Sangi ki
Appellant number 2.
Appellant number 2.
Appellant number 2. What do you want now?
I'm filing one IA for bail, Lordships.
Then what is this IA number 617 of 24? There is already an application for bail. And that is for both the appellants or appellant number 2?
It is for appellant number 1.
No, that is for appellant number 2 it is filed. You are appealing for appellant
number 2.
So there is already an application. This application you are pressing or some other application?
No, madam. I'm pressing that only, madam. Please.
617 of 2024.
617.
Okay. So
not pressed for the another. I'm not pressed for the another IA for bail, which is combined file.
No, there is only one application it has come. That is IA number 617 of 24.
My lord.
That you are pressing, right?
My lord.
So what sentence has been imposed?
10 year lordships.
How many years you are in custody?
He is in custody near about 5 matlab.
Near about
5 years.
From 26/11/2019.
So 5 years can be near about allow. 11 year about hobo na March masaru kemti near heijibo November ro.
4 years, 4 months.
That you say. So that principle, half of the punishment you remain, then you are to be granted. Or put up this matter after summer vacation.
Both the.
Yes.
For both the petition.
Yes. No. You have not filed any. For appellant number 1
is not filed.
No application has been filed.
My lord, my.
It will just come after summer vacation.
My lord, my.
Yes. Next.
Yes.
Item 47. Item 50.
May I please, my lord? Conviction under section 20B2C of NDPS Act, sentenced to undergo RI for 10 years.
You are facing the second item.
Yes, my lord.
So what is sentence you have wanted?
4/2/2020 custody, 4 year, 1 month, some odd days.
Right after summer vacation, along with the first one, that is CRLA number 704.
My lord, may I please, Your Honor?
I'll file paperwork. It will come 2 weeks after.
Paperwork on आगे bail ले जाओ. Yeah, Mr. Das, this matter will come after summer vacation because half of the sentence has not been undergone. So I'm keeping this matter to after summer vacation.
Lord, I was granted interim bail, my lord. I have filed on the surrender certificate. My
That
lord.
is available on record. There is no problem. Yes.
Maybe we come next week, my lord. We'll argue on
Sorry. Let it come after summer vacation along with so on. Yes, next.
Item 51.
May I please? No, on behalf of Mr. Officer, last occasion, my lord, director may produce the
Item 53.
Mr. Tripathi.
Pigeon petition, my lord.
Business petition achi.
My lord.
Okay, for engagement of Durlabh Ranjan Mishra. You are filing the V nama. All right. Is a sole appellant.
My lord.
All right. Mr. Durlabh Ranjan Mishra, the period the prisoner's petition for engagement of Advocate Durlabh Ranjan Mishra in state of Advocate B.R. Tripathi. Mr. Mishra files the V nama, which is taken on record. The name of Mr. B.R. Tripathi shall not be reflected in the cause list henceforth. So,
my name is wrongly typed. DUR. Not a full type.
कौन करिवे कोनांती
DURLLABH एठी अछि D
आपण गुटे कागज रे लिखि दियंतु आपनकर करेक्ट ना the name of the land and council for the appellant shall be correctly reflected in the cause list as se jo naata debe se uda kor yes so what about the IA for bail and sterilization of fine
present petitioner is convicted in 20B(c) of NDPS Act.
Yes.
My petitioner in custody since 14/3/2019.
So,
date of arrest.
So you have not completed
My 5 years completed 5 years 6 days.
Mr. Das.
As per the custody certificate, dated out 13/2/2024. 4 year 9 months.
13 to
2024 ତାମାନେ ଆଉ ମାସେ ମିଶେ ହେଲେ 10 ମାସ ହେଲା 4 ବର୍ଷ 10 ମାସ
ତାର କଣ ହିସାବ 5 ବର୍ଷ ତ
petition on custody since 14/3/2019.
just a minute, come to the judgment.
Page
What
9.
is your name? This
Page 9.
just a minute. Sindhu Kahar.
Page 9, 2, column 2.
Mr. Das, ସେ ଯୋଉ ସିନ୍ଧୁ କହଁର ସେକେଣ୍ଡ ପେଜ ରେ ଅଛି ଡେଟ୍ ଅଫ କଷ୍ଟଡି ଦେଖୁଛି
15/3/2019
14/3/2019
ଯୋଉ ଦିନ ଆରେଷ୍ଟ ହେଲା
ହଁ
15/3 ରେ ଫରୱାର୍ଡ ହେଲା
ହଁ 15/3/2019 ହେଲେ ତ ଆପଣଙ୍କର ହେଇଯାଉଛି 5 ବର୍ଷ
ବର୍ଷ
ହେଇଯାଉଛି ତା ଭିତରେ କୁଆଡେ ଯାଇଥିଲା କି ଫେଲ ହେଇଥିଲା କି କିଛି ଲେଖା ହେଇଛି ଅଦରୱାଇଜ ଏଟା ତ ପ୍ଲେନ୍ ଆଣ୍ଡ ସିମ୍ପଲ 2019 ମାନେ 2024 ହେଲେ 5 ବର୍ଷ ହେଇଗଲା 14/3 କି 15/3 ହେଲେ ତ ବର୍ତ୍ତମାନ ଆଜି ତ ହେଲାଣି 20 ତାରିଖ
1795 ଟୋଟାଲ ଡେଜ ଲେଖୁଛନ୍ତି 1795 ଡେଜ
ନାଇଁ ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ଜଣା ପଡୁଛି 14/3/2019 ରୁ ଏପର୍ଯ୍ୟନ୍ତ ଜଜମେଣ୍ଟ ପର୍ଯ୍ୟନ୍ତ 5 ବର୍ଷ ହେଇଯାଉଛି ଆପଣ କୋଉଠୁ ଆସିଲେ ହଁ ଯଦି ତା ଭିତରେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ତାପରେ ଯାଇଥିବ ଆଉ ଅଲଗା କଥା ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇନି ସୋ ଇଟ୍ ଇଜ କୋଭିଡ ପିରିୟଡ ରେ ଯାଇଥିଲା କି ତ ବାହାରୁ ଯାଇଛି otherwise the calculation is wrong are the learned counsel for the petitioner and counsel for the state the learned counsel for the petitioner submit that the petitioner has already undergone half of the substantive sentence imposed by the trial court and there is no chance of early hearing of the appeal in the near future and balance of convenience is in his favor and therefore the bail application may be favorably considered. He has pointed out from the page number 2 of the impugned judgment where the date of custody of the petitioner has been mentioned. Learned counsel for the state opposed the prayer for bail on the ground of seizure of commercial quantity of ganja from the possession of the petitioner and bar under section 37 of the NDPSR. Considering the submission made by the learned counsel for the respective party, the quantity of ganja is bar under section 37 of the NDPSR. While not inclining to release the petitioner on bail on merit, but taking into account the sentence imposed and period already under by the petitioner in judicial custody, I'm inclined to release him interim bail for 3 months and fix a date. He will file the surrender certificate. Yes, sterilization of fine. You gave your name in that paper.
Item 54.
Yes, Mr. Paul.
May I please, my lord, the appellant is
Item 55.
अच्छा which लिख देवे 54 ने देता
55 lordship both the I and withdraw the
Huh?
both the I is withdraw.
You want to withdraw?
We want to withdraw
On the ground, the appellant's legal heirs are not interested to the continue.
All right. Hard Miss A.K. the land counsel for this one. So, though
I am also present, my lord.
all right, I am recording your presence. And Mr. Sanjay Das, standing counsel for the Vigilance Department. Though the interim applications have been filed for condonation of delay to file the leave petition for continue the criminal appeal. So also the petition for leave to continue the appeal, the land and counsel for the appellant submits that the legal heirs are not interested to continue the criminal appeal. In view of such submission, both the interim application stands disposed of since the appellant has died, the appeal stands abated to dispose of according to I disposed of. You don't see what I'm stands abated. Yes, next.
May I pray for a grant of a free copy?
Free copy of the order.
The appeal is abated, my lord.
Yes, of course.
Yes,
That no legal representative to continue the appeal, so appeal abates.
Yes, my lord, oblige.
Here,
Item 56.
Yes, Mr. Rotham.
56, there is a delay of 658 days has been filed.
Any objection filed?
Yes, my lord, they have filed the objection.
So, what you are challenging here?
My lord, here is that the trial has concluded. All these witnesses have been examined by the after examination of the witness, the law and CJM Noyagor. Kindly, let's say, turn to page 16. The record is put. This is at the stage when the
What order you are challenging first?
11/11/2021 and the 30th/10.
11/11/21. Yes.
Before that, I am showing just 30th October 2021 order. That is at page 16.
Yes.
The record is put up today for verification. A year-old case, peruse the case record perusal. It is found that this case has been registered under the price sheet and circulation scheme along with the other sections of IPC. Trial was also commenced, but verification it is found that related cause of lodging the FIR is failed in rendering the service by the said financial institution in which the deposit has been made. Law advises that every person responsible in the management and affairs of the FIR and said establishment is liable to such failure, and so a humble view that the case has not been registered under Section 6 of OPID Act, but all the ingredients of Section 6 of the OPID Act are very much present. In this case, the law is well settled. So he transferred it to OPID court. This is at a stage when all these witnesses has been examined. And I faced the trial, full-fledged trial, since 2013. This is done. Now, after coming here, they have taken the cognizance, the OPID court Cuttack has taken cognizance 11/11/2021. That's so both these orders subject matter of challenge. My ground is that absolutely no cases made out under the Section 6.
That is to be examined first. The delay is to be
Yes, my lord. Delay. There is 658 days delay has been.
So, what is your objection, Mr. Mr. Patro?
You have filed already, my lord. It is more than near about 2 years, my lord. May I just explain, my lord, the position? I wrongly filed a CRLMC.
Okay. That you have mentioned in your ground of.
Yes, ma'am. I'm just explaining, my lord, the total period. The total period is 658 days. My lord, I have filed CRLMC on 20th March 2023 and it was converted on 31st August 2023. That's 164 days. And the pre-period is a COVID period, which is 110
Which
days.
paragraph you have explained it?
My lord.
Come to paragraph number 4.
4, my lord. That due to intervening COVID period and further due to transmission of the record or obtained certified copy and deposition of it, the petitioner could not obtain the order dated ethiking. After filing CRLMC on ethic in the process, there has been a delay of 464 days. I calculated it up to the CRLMC period. Now CRLMC conversion period has been added. Right. IA number so and so. This is an application for condonation of delay. Stamp report has pointed out there is delay of 675 days in filing this CRLA. The Mr. J.P. Patrol and special counsel appearing for the state of Orissa in OPID Act matter has filed the objection to the delay condonation application. After going through the amendments taken in the interim application, so also the objection filed and hearing the land counsel for the respective parties, I'm inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Put up the CRLA for admission next week. No, next week, 2nd of April 2024. Yes. Mr. Patron, you obtained the instruction that since this order impugned is dated 11/11/2021.
11/11/2021. 11/11/11. Since the order impugned is dated 11/11/2021, the up-to-date status of the case shall be obtained. Okay, maybe that thereafter charge might have been framed or witnesses might have been examined. So obtain that instruction. Yes.
Let's see. May also call for the status report.
Which one?
Let's
Alright, status report be called for from such and such. Which court it is pending?
OPID.
Come to that impugned order. So it is pending in the presiding officer of OPID designated court under the OPID Act Cuttack in CT number 15 of 2021. Status report be called there. In GR, no, not GR case. It's just city case number 15 of 21.
Okay.
Yes.
Item 57.
I'll take 1 week after.
Okay. Place for adjournment. Next.
My lord, pardon me. Item 44, my lord.
That is gone since long. 44 after summer vacation. Because Mr. Das was present there. You have not undergone half of the sentence. Why are you again mentioning?
Sorry.
Yes, next.
Item 58.
May I please, Your Lordship?
Yeah.
The appellant has been convicted under section 454 and 352.
Yes.
Yes, 452 and 354, and he is convicted under section 452 and 354, and sentenced under section and also convicted under section 372 IIPC, and sentenced to undergo
Which is the
RI
maximum sentence? 10 years.
Yes, 10 years.
How
And
many years you are in custody?
Custody since my lord can see in page 12 annex 1, 25/1/2018. 25/1/2018.
25/1/2018.
Yes, ma'am.
Judgment reflects that. Okay, so that means it is
more than 6 years.
6 years.
Yes,
and the maximum sentence is 10 years.
10 years, ma'am.
Earlier, the bail application
No,
was rejected.
he has never been eligible.
Never rejected.
No.
Yes, Mr. Dana. Are the land counsel for the petition land counsel for the state, considering the submission made by the land counsel for the petitioner, that the petitioner is in judicial custody since 25/1/2018, and as such he has already undergone 6 years or sometimes out of 10 years imposed by the land trial, no chance of early hearing, and hearing the land counsel so and so and going through the impugned judgment. I am inclined to release the petitioner on bail. Stay relation fine. Yes.
Okay.
Item 59.
May I please?
The appellant is convicted, my lord, for a period of 10 years in 376 2N. Last order, your lordship, 15/2/2040. 24, your lordship directed the state council to obtain instruction regarding antecedent and status of the victim and child.
No, apart from that, whether the victim has received compensation under
Yes,
this
sir.
one, so as per the judgment of the trial court, and also criminal antecedent, if any, so on so. Because he has placed the swanso which reveals that the appellant kept physical relationship and female child was born and all that.
Yes.
So what instruction you have received?
Well,
The victim and her child after examination of family members so on so on. They ascertained the jail person, the victim named is so on so on child. Further, nobody could able to say whether about the victim or the child known of condition at the location of the victim's known. At the location of the victim could not be established. Information regarding the amount of victim compensation received by her. This could have been easily collected from the DLSA. କହିବ ଆମକୁ ସେ କେସ୍ ରେଫର ହେଇଛି ଜଜମେଣ୍ଟରେ ଲେଖା ହେଇଛି କ୍ଲିୟରଲି ଯେ ତାକୁ କମ୍ପେନସେସନ କ୍ୱାଣ୍ଟିଫାଏ ହେଇଥିବ ନିଶ୍ଚୟ କେତେ ଆମାଉଣ୍ଟ କରାଯାଇଛି
compensation, my lord. Victim
no
compensation.
quantify ହେଇନି ଖାଲି
Nahi,
recommend ହେଇଛି
ଆଜ୍ଞା
so it could have
DLS rule.
DLSA ଗଜପତି ପାର୍ଲା ଖେମୁଣ୍ଡିରୁ ascertain କରି ହେଇଥାନ୍ତା କେତେ amount ହେଇଛି this type of report so you talk to him Mr. Das ask him to go to district legal services authority
I'll opt in.
the learning council for the state has produced the report from IIC Adva police station dated 4/3/2024 which is not satisfactory however the learning council for the state submits that he will ask the IIC Adva police station to approach the district legal services authority bracket DLSA Gajpati Parala Kemudi to obtain instruction as to how much compensation has been paid to the victim in portions of the impugned judgment and order passed by the London trial court. Put up this matter in the week commencing from 8th of April 2024. This is taken on record.
Obliged.
Item 60.
In common manner.
Or at the free copy of the order date.
Well, 20 years conviction under section 4(2) of the POCSO Act, Your Lordship.
Item 61.
My lordship, the under the interim application for bail and stay of re-election fine shall be considered. The case was admitted on 5th March 2024. The appellant is
What
convicted.
office? So when?
9-3.
9-3. So it can be hard. So what is the conviction and what is the sentence?
2-year murder.
What is the operative part of the judgment?
Operative part, my lord. Page 23 starts and 24 is the
15 days in under section 341.
51.
Then 3 months.
And fine 200.
3. Then 2 years under 354. Then 3-1 XI, it is for 2 years. Then a concurrent sentence. So it is 2 years, right?
No.
All right. IA number 2690 of 23. There is an application for bail. Heard Mr. Ashit Kumar Ota, Land Counsel, appearing through the virtual High Court, Mazing at Barifala. Land Counsel for the state submits that notice on the informant has been made sufficient since
Not any.
9/3/2024. Non appears for the informant. This petitioner was on bail.
Petitioner was on bail.
Petitioner was on bail, so bail allowed, stay realization of fine.
Item 62.
Hey, please. The appellant convicted for a period of 10 years, my lord. And he was all alone on bail.
Item 64.
May I please, your lordship, my lord?
Yes, Mr. Maji.
My lord, present appellant undergo rigorous imprisonment for a period of 20 years and pay fine of rupees 5,000. And the default of payment fine shall undergo arise for further period of 2 years for the offence punishable under section 4(2) of the Procedural, my lord. And rigorous imprisonment for 2 years and to pay a fine of rupees 1,000. In the meantime, my lord, the present petitioner during trial already released on bail, my lord. My lord, victim is a PW3. On a girl under child under 16 years of age, my lord. And PW 4 is doctor, my lord. Medical report is totally negative, my lord.
You have supplied deposition copy?
Yes, my lord.
So when the victim deposed in court in 23, she stated her Rest of the matter after lunch.
Miller. No, I have not. Start that. Miller. Only.
Sorry,
Adjournment.
Item 70
ଦି ଚାରିଟା ଅଛି ସରିଯିବ adjournment କୁ ମାଗୁ
70 ଟା notice ଯାଇଥିଲା sufficient ହେଇନି 3 is there
ନାଇଁ
short date
69
notice ଆସିନି
69 my lord.
Hello, 68, my lord.
Item number 74.
No OPID matter. Miller. 68 agala. No, 68 OPID.
Shubham 71 year lordship 71 year lordship notice sufficient
My lord. It's 2 events, item 72.73. 72 my lord, notice deposition copy ଦେଇନାହାନ୍ତି notice served. $72 my lord. 73 रे my lord, RI for 20 years 376D ଆଉ 37621 ଆଉ 6 box ଅଛି first time ଅଛି no it's not delay convent sentence
71 also delay is there 9 days 71 रे notice sufficient ହେଇଛି delay 9 days ଥିଲା deposition copy short
If anything you want to say, Mr. Giri, your matter has been adjourned. There is some problem. OPID matter absent to 2nd April.